Friends, in the Consumer Protection Act, you were told the definition of a consumer in section 2, clause 1, subclause D of the Consumer Protection Act 1986. A consumer, according to the section, a consumer is a person who purchases goods or who hires the services for his personal use. You have to remember that it is not for commercial use. Right. So now, yesterday, the Supreme Court of India, Honorable Supreme Court of India, declared that the beneficiaries also come as consumers under section 2(1)(d) because the definition is wide. Normally, we say that consumer is a person who is the so-called who is the purchaser of the property, but the beneficiary also will come under the definition of the consumer. Now, if you go into the details of the case, it will be easy for you to have an idea over the issue. Yesterday, the Supreme Court Justices Deepak Mishra and Abdul Nazir, while disposing Civil Appeal number 1042 by 2020 in a case Canara Bank versus United India Insurance Company Limited and another 2018. So, while disposing, they have categorically held that the beneficiary also consumer under section 2 of the Consumer Protection Act. Now, let us go into the details of the case. So, this happened in Karnataka. Definitely Canara Bank means somewhat you can understand it's happened in Karnataka. What happened is the agriculturists or the farmers, they have grown up a chili variety called as a Bayadgi chili variety, and they stored the same in Sridevi cold storage on during the years 2012 and 2013. So this is an incident relating to 2013. Right, friends, they have grown up the particular Bayadgi chili, దానికి కర్ణాటకలో ఏమంటారు మనకు తెలియదు కానీ సో ఆ చిల్లీని వాళ్ళు గ్రోన్ చేశారు. నార్మల్లీ ఫర్ గెటింగ్ సమ్ రెమ్యూనరేటివ్ ప్రైస్, మంచి రేట్ కోసం కోల్డ్ స్టోరేజ్లో పెట్టారు. సో ఆల్రెడీ మనం డిస్కస్ చేసాం కోల్డ్ స్టోరేజ్ పెట్టిన తర్వాత ఏం జరుగుతుంది అనేది. సేమ్ థింగ్ హ్యాపెండ్. ద కోల్డ్ స్టోరేజ్ స్టూడ్ యాజ్ సెక్యూరిటీ టు కెనరా బ్యాంక్ అండ్ కెనరా బ్యాంక్ gave loans to the farmers. This is the thing. So please remember, it is a tripartite agreement. So an agreement between the bank, the cold storage and the farmer. So here remember that the cold storage people stood as security. Right. So they have deposited, they have kept the so-called their chili products in the cold storage, and ultimately on the fateful night of 13/14/2014, maybe after 1 year or so, that may be the Sankranti season, some electric short circuit occurred and entire cold storage was gutted into fire. So, police report ప్రకారము సడన్గా షార్ట్ సర్క్యూట్ చెలరేగి మంటలు వ్యాపించి లోపల మామూలుగా ఉన్న స్టాక్ కేవలం ఈ మిర్చే కాదు రకరకాల స్టాక్స్ ఉన్నాయి, అన్ని బూడిదైపోయాయని చెప్పి దే గేవ్ ఎ రిపోర్ట్. ఎంటైర్ స్టాక్ వాజ్ destroyed. Now, they filed a case, normally the cold storage, they filed a case against the insurance company for the loss sustained by them because it is covered with 5 crores of insurance with the United India Insurance Company. So 5 crores, సహజంగా వాళ్ళకు కూడా డౌట్ వస్తుంది. So then they have employed their own investigate officers, retired police people, and ultimately they came to the conclusion that it was a false case, purposeful, palpably false case. No so-called electric short circuit. They wanted purposefully. They have set fire to the cold storage and damaged the property. Now they are claiming the insurance claim. fine. It's okay, the dispute is going on. Now, here what happened, of course, the dispute is not settled. Now, the agriculture or the farmers, now we can call them as the beneficiaries. The farmers who pledged their so-called chili to the bank, they also became parties and they filed a case in the Consumer Protection Council for the deficiency of service against the bank as well as the insurance company. Of course, they held the bank to be negligent, and of course, in turn, so they filed a case against. They wanted the riots wanted that they should be made as parties. That means they should get benefit from the insurance, whatever the owner of Sridevi cold storage gets, and it should be apportioned between the cold storage and also the farmers and some other things. So this is the case. Now, insurance company raised two objections. Please remember, గుర్తుపెట్టుకోండి, అడ్వకేట్స్గా మనం ఈ పాయింట్స్ ఎక్కువ తెలుసుకోవాలి. కేసు పెడితే ఉంది ఎవరైనా పెట్టొచ్చు. ఇక్కడ 2 points. One is privity of contract. గుర్తుపెట్టుకోండి, there is no privity of contract between the farmers and the insurance company. 100% right. ఎందుకంటే ప్రీవియస్లీ ఇంకో కేసులో కూడా రాంగ్ అని చెప్పాను, గుర్తుందో లేదు ఒకసారి చేద్దాం. ఇక్కడ ఏంటంటే ఎలిగేషన్ ఈస్ నెంబర్ 1 ఎలిగేషన్ ఈస్ that allegation, the defense by the insurance company is number 1, that no such electric short circuit took place. This is also a five-state case, concocted case, false case. Number 2, there is no privity contract. Why should they pay the insurance to the agriculturists? Why should they pay to the farmer? There is no contractual agreement between the insurance company and the so-called farmers and so-called beneficiaries. It is their contention. ఈ కంటెన్షన్ ఒకసారి మళ్ళా మనం పక్కకి వెళ్దాం. లెట్స్ గో టు ది కేస్ ఆఫ్ నెగ్లిజెన్స్, డోనో వర్సెస్ స్టీవెన్సన్ 1932, where the love pair went to a restaurant and the boy ordered for the ginger beer and it was supplied in an opaque bottle, and consuming the same, and first peg was consumed by the girl and second mug of beer. Then she found the remnants or dead body parts of a snail, and she vomited. She got mentally disturbed. She got physically that's injury. Then we filed the case. In that case also, the beer company, they claimed the so-called no privity of contract. So definitely, then that House of Lords, they brought the neighbors principle. Even though you are not having direct connection, indirectly you are a neighbor. Here also the insurance company, the matter went to the state commission. State commission also held the insurance company liable to pay damages to this person, to the cold storage, and as well as the agriculturists also. So agreed by the decision of the state commission, they went to the National Commission 2018, and National Commission also agreed or held the order of the State Commission to be correct. Now they have come to the Supreme Court. Here Supreme Court expanded the meaning of the consumer. Normally we believe that the persons who purchase the goods, they are only come under the purview of consumer. Here the insurance company, directly they are not connected to the insurance company, directly they are connected only with the cold storage, a part with the bank, that's all. But here please remember, the Supreme Court found fault with the bank also. You people, you did not conduct any inspection of the cold storage periodically. Therefore they were having so much of audacity, the stocks were piled up, and ultimately since there is no purchaser, somehow the incident took place. No doubt there is no record to say that it is a false case. So the agriculturists proved that it is a true case, because on receiving information they visited the place, they called the police came there, they called the electrical people also. Electrical people stated that it is a so-called short circuit or things like that. So when the evidence is 100% proof that it is a accidental fire due to short circuits, the claim of the insurance company that is a false allegation, all these things are not accepted. They have to pay they have to indemnify the cold storage. At the same time, the cold storage people, they have to apportion the money to the agriculturists, because their product was also in the cold storage, right? Here the most important point is the cold storage was insured along with the property, along with the material. So the cold storage people cannot happily pocket the so-called 5 crores in their pocket. Now they have to dispose a portion to the agriculturists. So beautiful judgment given by the Supreme Court. Here the important point is that beneficiaries also will come under the purview of the consumers. Thank you very much.